Okay. Good evening, everybody. My name is Phil Stern. I'm the attorney for the board. We are all here tonight subject to a law called, can you hear me?
Yep.
Called the Open Public Meetings Act. And that law requires that, with a few exceptions, everything is discussed here in the sunshine. It's subtitled the Sunshine Law. One of the exceptions to the sunshine is that the board has the option to discuss personnel matters in what's called executive session, where it's only the board without the public listening. Whenever an employee is going to be discussed, and there was a recent New Jersey Supreme Court decision on this matter, whenever there is potential for adverse action or anything negative regarding an employee, they must receive what is called a Rice notice. And that Rice notice simply says the following. One, the board may have a conversation about you in executive session. You, employee, have the right to tell the board, no, I don't want you to have that conversation in executive session. I want you to have it in open session. And that employee then has the right for any discussion would take place in open session. Mr. Eric Jones received a Rice notice and opted to have the conversation about any board concerns that there may be in open session. And that's what we are going to open with tonight. The board has concerns that it would like to discuss. Now, just to be very clear, this experience is very much like a fishbowl. This is not a dialogue between the board and the audience. This is the audience, and especially and particularly Mr. Jones, having the ability to listen to the conversation that the board is having. This is not a, there will be no audience participation in this. It is simply the board. What would normally happen in executive session is happening here because Mr. Jones exercised his right to ask for this to be in public. And so, are there any questions from the board on this process, or did I make that pretty clear? Anything else?
No, exactly.